Hi, I'm Emily Jordan. I'm Associate Solicitor at Forbes Solicitors. I work in the Housing and Regeneration Litigation team, and I mainly deal with leasehold matters, both residential and commercial. I also deal with commercial contract dispute matters on behalf of registered providers. Today I'm going to be doing a session on recovery of service charges during COVID-19. We've had some questions sent in by clients on the topic, so many thanks to those who have sent in questions. So the first question says, what do we do about the cleaning and gardening that hasn't been taking place? Should we be reducing their charge as they're not likely to receive the full service charge for the year? This client has had one email from a managing agent to say that they won't be refunding any service charges as there will be work that will be needed to be carried out once lockdown is lifted, such as deep cleans and extra gardening, and that will cover the balance of the costs owed. Well, local authorities and housing associations are still obligated under the terms of their leases to maintain the building they own and to provide other essential services, which may of course include cleaning. The requirement for social distancing is presenting challenges in meeting those obligations. I'm sure many of you would prefer to maintain business as usual if possible, as not carrying out maintenance now will only lead to additional workload and backlog when things do return to normal. So what does the lease say about frequency of services? If your lease is silent, can you make it up at a later date in the year by dedicating extra time to gardening and cleaning, which will likely be needed anyway, as deep cleans might be required or extra gardening where landscapes have become overgrown? I'd suggest that you carry out an analysis of your schemes and consider rescheduling the frequency of services or delivering them in a different way, and complete a risk assessment on your decisions. For example, I wouldn't consider window cleaning as essential, whereas a cleaning service is still likely to be needed, but perhaps in a different way and at different frequencies, maybe more frequent cleaning of handrails and communal door handles. Also consider if you're going to have associated costs, additional costs for PPE equipment. You'll need to factor those in. Remember, you're invoicing leaseholders for the costs you've incurred and not for the service received. It is, of course, easier to carry out these assessments where you carry out the service in-house, and you'll know about your extra care or supported schemes, which will have different considerations, so assess each scheme or block individually. Where the work is contracted out, you should look at the terms of your contract. Is the contractor entitled to continue to charge for services that cannot be delivered? Are they claiming force majeure, and are they claiming it rightly? If not, how can you monitor that extra work is going to be carried out post-lockdown in order to respond to any complaints you receive from residents? We can advise on specific terms of the contract, but we'd obviously need to see the contract. But I would encourage you to have open discussions and effective engagement with your contractors to discuss which services you consider to be out of necessity, how you can reprioritise, and how you can support them with cash flow. Of course, all businesses are affected by COVID. This client has an LSCE scheme, which is a leasehold scheme for the elderly, with a sheltered coordinator attached. And they're still delivering the service remotely, but the responsibilities of the sheltered coordinator have been reduced due to not being able to do everything they'd normally do. This client asks, should we be looking at reducing the leaseholder's charges, or is it adequate to keep the charge the same as the shelter coordinator is still working their allotted times? Well, as previously discussed, each scheme should be assessed individually to consider if the service can continue at its usual frequency or whether it can be delivered in a different way. What does the lease itself say about the responsibilities of the shelter coordinator? If the leaseholders continue to benefit from the service and the cost which you're incurring remains consistent, then the leaseholder should pay for it. Working the same number of hours is good justification that the service is still being received, albeit the nature of the service might be slightly different to normal. As a general thought, however, it is worth bearing in mind that a short-term partial rebate of, say, 10% of that element of the cost over the worst effective months due to COVID may go some way to reducing dissatisfaction on the scheme and reducing the risk of complaints or challenges to the tribunal by leaseholders. This question says, we've got a lot of residents who are saying that they won't pay for a charge that they haven't received a service for. Obviously, if they are paying in retrospect on actuals, then that's fine, but what about those who are budgeted for in advance? I'd advise you to consider the terms of the lease relating to invoicing of service charges. Is the leaseholder to pay a proportion of the landlord's annual costs? If so, will you be able to make up for the lockdown period by providing extra services so that across the year, the leaseholder is receiving the service that was budgeted? Consider how you calculate charges. If on an hourly rate basis, then it should be straightforward to work out by adding up the hours worked. In the meantime, I'd suggest reminding residents that their costs are calculated annually and explaining to them it won't be possible for you to know the overall impact on costs until year end, so it may be some time before all the numbers come out in the wash. Remember, for organisations charging variable service charges, leaseholders do have the right to challenge the level of service charge being paid at first tier tribunal. Additionally, where you've covenanted to provide a service and it's not being provided, you may be in breach of contract and liable to compensate the residents for the period in question. And this is a factor that the tribunal will often bear in mind. Therefore, if you do scale back the service being delivered and don't reflect this in the service charge being charged, a leaseholder could make an application to the tribunal. Under a variable service charge, there are two opportunities to alter the charges. The first is when budgets are issued prior to the start of the financial year. And the second is when actual costs are known and a statement is sent to residents, which is usually within 6 months of the end of the financial year. If you budget an invoice in advance based on estimated charges and it's clear that you cannot provide the service intended, this can be dealt with at year end as part of the reconciliation process for 2020/21. Then consider what the lease says about dealing with surplus funds. Are you to refund these to the leaseholder or carry them over to next year? The other option is to recalculate service charges once a decision has been made regarding the continuation of services during COVID. So once you've calculated the financial impact, you can apply any reduction in costs at the earliest opportunity. If there's an increase in cost, you'd have to see what the lease says about whether variations can take place other than once per year. It can be harder to put charges up than to put them down. When our situation returns to normal, any further changes will also be picked up by reconciliation at year end, but the adjustments difference will be smaller than in the previous option. Option 1 is of course more straightforward and less time consuming administratively for you, but option 2 might encourage leaseholders to continue to make their monthly payments on the basis that they have been altered to reflect the service currently being provided. It's also more time reactive and reflective. It wouldn't impact negatively on current leaseholders if the lease was assigned to another person before reconciliation is completed. The final option is to credit accounts as a negative service charge to reduce the charge by the appropriate amount. This wouldn't affect the payments made by leaseholders, but it does help you to track what would have been spent and to manage budgets. What about fixed service charges? Well, we consider that registered providers who charge fixed service charges should also consider carrying out one of the processes discussed on an exceptional basis. And that would be to pass any reduction in its costs on to leaseholders. This does, though, require more careful thought, as fixed charges aren't meant to fluctuate in accordance with underlying costs. I've also been asked, can we charge for additional cleaning that may be required within a scheme setting? Well, I'd advise that you check the lease terms as to your obligations on cleaning. Is it necessary to charge extra if there's been a period of time where cleaning wasn't carried out due to restrictions? If not, and there is a need for a deep clean, are the terms of the lease wide enough in respect of your cleaning obligations, such that you can justify carrying out a deep clean? If so, and the charge is reasonable, you can recharge the cost of service charge as you are just invoicing for the costs incurred. The question is whether you are required under the lease to provide that service, such that the leaseholder is obliged to pay the landlord's costs in providing the service. We can envisage that although a deep clean might not normally be justified in usual circumstances, given the current unprecedented situation, it could fall within what would be reasonably contemplated by way of a communal cleaning service. Of course, the tribunal still has discretion to reduce a service charge if it's found to be unreasonable. Now, it would depend on an individual landlord's circumstances as to whether it could decide to absorb any additional costs as an alternative to recharging to leaseholders as service charge. Not only is COVID-19 impacting financially on leaseholders' ability to pay rent and service charges, we do appreciate it will inevitably also affect you as a business. The next question concerns fly tipping. We've seen an increase in fly tipping, so we would like to consider charging this to blocks where we cannot identify or recharge the suspects. Most places will have a grounds maintenance charge, and we'd like to add the charge there, management of in-store cleaning budgets within a service charge. Some guidance about unforeseen costs would be useful. So leaseholders only have to pay a service charge for work or services if the lease contains a clause giving the landlord the power to recover the cost of the work or services from them. Your lease may be very specific in its wording, setting out quite precisely which work or services you can charge for. Or the clauses may be very general and simply refer to the costs of repairing and maintaining the structure of the building. It's a question of what was reasonably contemplated by the parties at the time that the lease was entered into. We'd expect that references to communal cleaning or grounds maintenance should usually include removal of waste and fly tipping. But we don't think that references to maintaining the structure or exterior of the building would allow for removal of waste. Maintaining the common parts of a scheme of buildings or of retained land might be wide enough to include this, especially if the waste may cause physical damage or defacing of the fabric of the property, but it could turn on the scope of the definitions used in the lease itself. More modern leases tend to include a wider range of activities, catch-all definitions and sweeping up clauses, whereas leases drafted in the 1980s and early 90s tend to be more rudimentary and minimalist. So consider each scheme and lease separately. We spoke about delivering services in a different way. Does the scheme have a caretaker whose duties under the lease include general upkeep of the scheme? Could they reallocate some of their time to deal with fly tipping? Also consider why you might be seeing an increase in fly tipping. Although it shouldn't be condoned, it isn't surprising there's been an increase as refuse sites have been closed to the public. Refuse removal is a combination of budgeted and reactive work. It should continue to be delivered in the normal way, but it might increase due to more residents not disposing of refuse correctly. Consider if you've got any vulnerable customers who are self-isolating. Could you offer them assistance with disposing of refuse bags on a regular basis? This would, of course, impact on service charge costs, so you must keep reasonableness at the forefront of any decisions. I've also been asked, are there consumer credit implications if we agree repayment plans that are over 12 months? Also, what is the process for applying for a consumer credit licence if one is needed? Bearing in mind we hold one for debt advice in another part of the business. Well, the simple answer is yes, there are consumer credit implications, so tread very carefully. If you enter into a contract for supply of credit for over 12 months, and or in instalments over certain periods, then this can be caught as a regulated agreement under the Consumer Credit Act. You would therefore need a consumer credit licence if you entered into one of those regulated agreements with customers, unless one of the limited exceptions applies. Unfortunately, the exceptions that you'd probably want to rely on don't normally apply. But there is a get around to deal with payments without it being considered a regulated agreement requiring a licence. And in brief, it goes like this. There is money due under the lease and owing by the leaseholder. Payment is due forthwith or in accordance with the timescale set out in the lease. But if the leaseholder makes payments within a reasonable time frame, we as the landlord indicate that we will forbear on recovering the debt in accordance with our debt policy and procedures. So this is more a forbearance of not exercising any right you have as a landlord to recover the debt, rather than it being a contract for supply of credit. The key difference is that under forbearance, you can, in theory at least, insist on payment of outstanding amounts at any time, hence why it's not an enforceable credit agreement. You would, though, need to keep the situation crystal clear when you're corresponding with leaseholders on the point. We would need to see the terms of the specific lease and the details of any payment proposals in order to advise properly. But of course, if payments are just being made in accordance with the lease, there's no credit to worry about anyway. Or if the repayment plan is for a term of less than 12 months, it shouldn't be caught by the Act. In terms of applying for a credit consumer licence, if you have a licence in another part of the business, then I'd suggest you get advice on expanding that current licence to cover service charges. And our GPI department can offer assistance in that respect if needed. And this question deals with presentation of audited accounts. So where we normally present audited accounts, what can we do during our current situation? We will be sending the accounts by letter, but there is a requirement in the lease for them to be presented. So I'd suggest you consider what the lease actually requires of you with regarding to presenting accounts. Just because you might have provided your account in a particular way, for example at a residents meeting for years, doesn't necessarily mean the lease requires it. If the lease though does require it, then think outside of the box. Would you normally present accounts during a residents meeting? Instead, could you pre-record this and send a link by email or text for residents to view electronically or by DVD? Consider elderly residents or those who might not have internet access. I suggest you provide your contact details in a letter and invite residents to call if they have any questions on matters that they would ordinarily raise at the meeting in person. And reassure residents that this is a one-off, and COVID depending, you intend to be back to normal in presenting accounts in person next year. Consider as well the meaning of the word present. It could just mean to supply, provide or furnish in a written format, such as the presentation of a cheque or an invoice, in which case providing the information in writing would still meet the contractual requirements. A physical presentation at a face-to-face meeting is unlikely to be the intention unless there are particular quirks on a development, such as an elderly resident scheme. As ever with leases, wording and context is key. On a customer care level, you may still need to do some work to explain to residents about the reasons for any departure from usual practice, even if it is legally permitted. The longer term implications of the current pandemic may require you to reevaluate and redesign your existing processes anyway. This is especially so if some form of lockdown is reintroduced, or if social distancing continues into next year and beyond, whether generally or for particular vulnerable groups. It will of course only be a problem if a resident makes it a problem, so do work with them and alleviate any concerns they have. Section 20 consultation requires us to allow the inspection of procurement documents, Normally we would put an office address as the place for inspection due to the large number of documents related to a procurement process. However, there is currently a risk to allowing customers into buildings, so what should we do? Again, I'd encourage you to think outside of the box to ensure that those who would ordinarily have come to your office to inspect the documents still have an opportunity to inspect. Could you set aside a designated room, such as an interview room, with gloves and hand sanitizer provided, to which customers can be escorted whilst observing social distancing? If access is not normally being permitted to all customers, could you make an exception for the relatively few number of customers who may wish to take up the opportunity, and explaining that access is by appointment only? Even if your regional offices are closed, could you offer an appointment at your head office, bearing in mind that the regulations allow for considerations of reasonableness, even under the current unprecedented circumstances? Could you make an arrangement with a rent-a-room company for short-term bookings rather than using your own offices? Can you laminate the documents and put them in a ring binder to make it easier to wipe them down afterwards? Or most simply, could you offer to print out a customer's own personal copy to take away with them if they just come to the front door? You might decide against sending full documentation to all leaseholders by post due to the volume of documents, but it is an option. And consider exactly what documents you are legally required to provide to leaseholders under Section 20. At stage 1 of the process, it's usually just a description of relevant matters, so a summary of the scope of the works or contract. At stage 2, the obligation is to set out a summary statement relating to the proposals or quotes and making those proposals or quotes available for inspection. So it's only likely to be onerous if the consultation relates to a significant procurement exercise. Or in addition to them inspecting the documents at your offices, if this can be managed, could you reduce the risk of personal contact and invite leaseholders to contact you in the event that they do want a hard copy posted to them? I highly doubt that everyone will ask for a copy. As an alternative, could you consider providing a web link to view documents online if the leaseholder agrees, or offering to send documents by email to those who request them? Of course, posting a hard copy would still need to be an available option for those who don't have email or internet access. The key point to remember is to keep your residents informed and to manage their expectations. Is it business as usual? How are you revising service charges? Will service charge costs go up or down? What are you doing about payments, and will you be taking legal action for non-payment? I'd suggest that you provide a point of contact for residents to discuss any concerns or their individual circumstances. But please do contact us if you have any questions regarding the session or any particularly troublesome cases that are keeping you up at night. Thank you again to those who sent in the questions, and thank you for watching. I look forward to hearing from you if you do have any queries.